Welcome back to The Verdict, MLMIC's podcast where we explore pivotal topics in medical professional liability insurance, healthcare law, and healthcare risk management. I'm your host, Tammie Smeltz. This year is truly a milestone for us at MLMIC as we celebrate our 50th anniversary of dedicated service to the New York healthcare community. We're honored to have you join us as we continue to bring you insights designed to support and inform your practice. Today, we're going to discuss a case study with Jonathon Erman, a partner with Amabile Erman. Good morning, John, and thanks for being a guest on The Verdict. Can you tell us a little bit about the case that we're going to discuss today?
Sure, Tammie. Thank you very much for having me on board this podcast. Just by way of background, I've been defending insureds now for 27 years. I work for various hospital systems, and this is one case that, for various reasons, has stuck with me over the course of my career. By way of background, this is a case that centers around the, quote, failure to diagnose melanoma, a skin cancer. Let me take you back in time and explain to you how this medical malpractice case unfolded. We're going to go back many years to 2008. The patient, who was then 21 years of age, had what we all have, moles. She had moles on her breast, and she also had some moles on her face. And in April of 2008, she contacted a local dermatologist in Staten Island and was told by the receptionist that based on availability, she had either the option to see a physician's assistant who was working at the dermatology practice, or she could wait and hopefully be able to see the dermatologist herself. This was the spring of 2008. The patient opted to be seen by the physician's assistant, who, upon a physical examination, noticed that there were various moles that he, in his opinion, wanted to biopsy. He spoke to the patient that these moles looked somewhat suspicious, that a biopsy could rule out anything troubling, and the patient ultimately decided 1 week later to undergo this biopsy. The biopsy was performed by the same PA. A biopsy, for those who may not know, can be done in various ways. In this way, it was done by a shave biopsy, where portions of the mole itself are removed. They are sent to a lab, reviewed under a microscope by what's called a dermatopathologist, and the results are then conveyed to the practice as to what the next steps should be. We know from reviewing the medical records after the case was initiated that the laboratory had concerns about the biopsies. They found that, specifically as it pertained to the patient, who again was 21 years of age, this is the spring of 2008, she's just finishing up her last year of college at the College of Staten Island. They found that the mole on her cheek had unusual features. They described it as being a, quote, spitz nevus with unusual features, with a wide excision being recommended. This result was conveyed and transmitted to the dermatology practice. The results were troubling. A spitz nevus, for those who are not in the field of dermatology, was usually and is commonly known as a benign melanoma. Melanoma is a skin cancer. It's a very bad type of cancer. And the pathologist was recommending to the providers here, the dermatology practice, that a wider excision was required because they could not determine whether or not this mole was cancerous or not, in lay terms. The results of this pathology were received, and in fact, documentation reflects that the office was so concerned about the results that they actually underlined the words wide excision is recommended. Now, we know from the office records, and this will play a role in what ultimately was and is the case that unfolded, was that the patient was next seen not by the doctor, but again by the PA. There were criticism about that when you as a physician receive results that could be troubling, that could be concerning by any stretch of the imagination here, that patient should be seen by a doctor, not by a PA. In this case, once again, the patient was seen by the PA who performed the biopsy, and there was a divergence of a testimony, but essentially the patient was told by the PA that because a wide excision was recommended by the pathologist to rule in or rule out the cancer, we would like you to be seen by a plastic surgeon. As discovery or the information gathering process unfolded during discovery or during the trial or during the case itself, the witness, of course, testified that she was told unequivocally that the reason for the referral to the plastic surgeon was for cosmetic reasons, that the mole was not cancerous, that the reason for the referral to the plastic surgeon was to clean up the scar from the biopsy, and that was the only reason. The patient, being that it was now the summer of 2008, for whatever reason, opted not to see the plastic surgeon. We learned from the discovery process 1 year later that that same area that had been previously biopsied became itchy. It started to bleed. It became crusty, as described by the patient. She ultimately decided to see another dermatologist in Staten Island, who once again performed the biopsy. But this time, the lab results were not unequivocal. They indicated that she had melanoma. Unfortunately, the patient had a very aggressive type of melanoma. It was initially diagnosed as a stage 3 melanoma. Within 6 months, the melanoma metastasized first to her brain, ultimately to her bones. And then within 1 year, she passed from this unfortunate, terrible disease.
Thanks, John, for explaining all the detailed medicine. Can you tell us a little bit about the lawsuit?
Now knowing what occurred from a factual perspective, let's discuss it from a legal medical perspective. Okay, so in 2010, as this is all unfolding, the patient and her family sought out the services of a lawyer. The lawyer, after obtaining the medical records, made a determination after consulting with a physician that there was a reasonable basis to bring a suit. My client was initially served with documentation reflecting that she was named as a defendant in a lawsuit being brought forth by the patient. When she looked at the caption or the legal documents, she also noticed that not only was she named, but her physician's assistant who was employed by her, along with her practice, her professional corporation. Now, in speaking with my client when the case first started, she had no idea who this patient was. I want you to remember that the patient was never seen by my client. She was seen by one of her employees, a physician's assistant. Now, in the state of New York, as in most states, physician assistants are allowed to practice under the supervision of a physician. In this case, my client, who was previously a chairman of a department of dermatology for a major metropolitan hospital, had 3 offices. She employed PAs at all of her offices. She had nurse practitioners. She had medical assistants. Under the state of New York's laws, you as a physician have the right and the capability to employ physician's assistants who are more or less an extender of your services. In this situation, she hired a physician's assistant who the patient opted to see in her absence at her practice. who, as you heard, provided a course of treatment, performed a biopsy, and discussed the results of the biopsy with the patient. Nevertheless, my client, who employed that physician's assistant, was brought into the case. Even though she never saw the patient, never interacted with the patient, never had any communication with the patient. But because she employed the physician's assistant, she was named as a defendant and could be held what's called vicariously responsible for the actions or inactions of her employee, in this case, the physician's assistant. Now, this is going to play a role during our discussion because there were experts who reviewed this matter. And when I say experts, in every medical malpractice case, we, as your defense attorneys, will hire neutral physicians to review the materials, to review the medical records, to review the documents or the pleadings, the claims that are being raised against you as a insured, to provide us with an unbiased opinion as to whether or not the standard of care in the treatment that was rendered to this patient abided by the standards of care in the field of dermatology. Questions were raised by our own experts, people that we retained, who said, if it was me, I would, as the physician, be the one to consult with the patient after receiving these results. These are some of the pitfalls when you hire physician's assistants that you as a physician need to be cognizant of. That yes, while a physician assistant is licensed by the state of New York, they may have their own malpractice insurance. You as the employer are vicariously or ultimately responsible for their actions. And this would play a role in how this case ultimately resolved.
So I just have a question. So when the results came back and they were concerning, why the decision was underlined, and I know the patient saw the PA again, did the physician know about those results at all, or was this just surprise when she got served?
Interestingly, when the physician was confronted with the lab results, when we met and during the course of litigation, if you unfortunately are named as a defendant, as a medical provider, you will be meeting with your counsel on numerous occasions. And I remember specifically discussing this case, meeting with the doctor in her room. And when we discussed the results and I showed her the results, she recalled seeing these results and she herself underlined it. And when questioned and asked, well, why did you not see the patient when an appointment was scheduled to go over these results? She did not have an answer other than to indicate to me that she should have.
Okay, and now I understand our expert's point of view on that.
Yeah.
Unfortunately, that's what happened.
So my experts all said the same thing. They said, listen, a PA can convey the results, right? But we're not dealing with, an elevated cholesterol level here. We're dealing with something that the pathologist is saying, we can't rule it in, we can't rule it out, wide excisions recommended. This is the time where the physician needs to be the one to sit down with the patient, discuss with the patient why we want you to go see a plastic surgeon. We're not dealing with a body part that's covered. This is a 21-year-old, beautiful by any stretch of the imagination, who's going to have a scar on her face. That's something that, as a dermatologist, I don't know if you want to take that chance in doing a further wide excision. You'd refer the patient out to a plastic surgeon who could perform the layers of stitches necessary to hopefully alleviate the need for permanent scarring.
Right. And just, not knowing all that much about the case and trying to give the doctor the benefit of the doubt, I was wondering if the PA kind of just like took over the patient, and the doctor didn't know those results. But the fact that she did is problematic.
That was what our experts opined that while a PA is more than adequate for purposes of conveying and making the proper recommendations, in this type of situation with a young patient, with these types of results, it really behooved the physician to sit down with the patient and convey not only the results, but the recommendations.
Yeah, for sure. And before we move on to a little bit more of the discovery, what was documented in the chart? Do you remember what the PA documented pertaining to the conversation she had with the patient?
You know, as a physician, you're told during your residency program, at least I hope you are, that if it's not documented, it didn't happen. Unfortunately, in this case, the concerns were the lack of documentation. While the physician's assistant submitted to what's called a deposition, that is, before trial, the capability of all parties to question a witness under oath. In this situation, during his deposition, the PA indicated that he had a recollection of his conversation with the patient. He recalled explaining to the patient what the words meant in the pathology report. And he specifically recalled providing the patient with the name of a plastic surgeon for purposes of the patient scheduling a consult. While the documentation did reflect the name of the plastic surgeon, it did not indicate, nor did it discuss or memorialize what was actually said with the patient during that brief encounter. Would it have been better for the PA and my client that the PA memorialized the conversation, the reason for the consult to the plastic surgeon? Of course. And that unfortunately became the he said, she said, because there was no formal memorialization of the conversation. Earlier, I discussed that the patient, indicated that she was told to see the plastic surgeon for cosmetic reasons. The PA testified that the reason for the plastic surgeon was because the pathologist recommended it, that the biopsy results were not definitive, that further specimens were required, in this case, a quote, wide excision.
Yeah, and I think that's a lesson learned for our listeners, right? That it's really imperative that you document your conversation in the chart completely, and especially when it comes to relaying like critical test results to your patients.
Yeah, and just from a practical standpoint, it's very difficult. Listen, you as a physician or a nurse practitioner or a physician's assistant, you're seeing many, many patients in any given day. Will you have some recollection of the patients you see? Of course. But when we talk about these medical malpractice cases, we're talking about treatment that could have been rendered 2 years earlier in time. During the deposition, we're talking about treatment that was rendered almost 3 years ago. Now, for you to have a specific recollection of your conversation, it becomes extremely difficult unless it was, in fact, memorialized. That's why we always recommend, as much as you can possibly put down on paper, please utilize the paper, utilize your EMRs or your electronic medical records. Provide as much documentation as possible.
Exactly. Now, I know you said that the plaintiff was deposed, and I think she may have passed away shortly after her deposition. And I also remember you saying this was a very emotional case. How did the deposition go? What was that like? Can you tell our listeners a little bit about how sympathetic it was and how that plays into deciding whether to take a case to trial or possibly settle it?
Okay, that's a great question, Tammie. Let me go back a little bit and explain to your listeners the process. Hopefully they have not been through this process, but if they have, just bear with me for a couple minutes. When a patient brings up a malpractice lawsuit against a physician, we as the defense attorneys have the opportunity to obtain all the medical records surrounding that patient. We also have the right to conduct what's called a deposition. Now, a deposition is the capability of attorneys on behalf of the named parties to question, in this case, the plaintiff, as to what she may recall, conversations with the medical providers, and essentially what occurred to her after, in this situation, the alleged delay of diagnosing the melanoma. Now, the same holds true for the plaintiffs. They have the capability to question you, the medical provider, as to how your office was working in that time period. Who was working at your office? What treatment was rendered? Why was a physician's assistant as opposed to you seeing the patient? How does your office collect the pathology results? What do they do with the pathology results? Do they document when they receive the results? Do they document when the patient doesn't show up for her return visit in a timely manner? It is the opportunity for the patient's family or the attorney to question you under oath. Now, in this situation, unfortunately, the skin cancer had metastasized to her brain, ultimately to her bones, and then unfortunately to her lungs. When we had the opportunity to conduct what's called the deposition, I have to be honest, I've seen many cases before. I've handled hundreds upon hundreds of cases. This is one that stood out. You have to envision a situation where a then 21-year-old beautiful woman is being helped into your conference room in your office. She's utilizing a walker. She's being assisted by her father. She has an oxygen tank attached to her for purposes of breathing. We conducted the deposition as quickly and as efficiently as possible, but I can tell you that seasoned attorneys who were present for this deposition walked out and all shared essentially the same sentiment. It was a rough, troubling, emotional type of day. And if we, as seasoned attorneys who've handled hundreds, if not thousands of medical malpractice cases, felt this way, our concerns conveyed by all of us unanimously were, what would jurors say if confronted by the patient in the condition that she was in? And as much as you may feel as a medical provider that everything was done, that patients have their own responsibility in following up or seeing the right consultants that are recommended to you, there are certain times in these medical malpractice cases where all of us have to put ourselves in the shoes of a potential juror. Now, these cases are not decided by doctors, lawyers, professors. They are decided by your, quote, peers, jurors. In the state of New York, there are 6 jurors who will decide whether or not you departed from good and accepted medical practice in the care and treatment rendered to the patient, now the plaintiff. These jurors come from different walks of life. But one thing that is constant is that these jurors are all human. They are parents, they are uncles, they're aunts, some of them are grandparents. And I can tell you that when we as attorneys saw how she appeared for her deposition, we had the major concern, rightfully so, that sympathy would be the overriding concern should this matter proceed to trial.
Can you tell us a little bit about the summary judgment motion, and what are your thoughts about these types of motions being granted?
Doctors are their worst enemies, right? So you can get an expert from anywhere to come in and say that someone departed from good and accepted medical care. And as long as you pay them enough, they'll say it, right? So we'll move for summary judgment in all these types of cases, saying there's no, quote, triable issue of fact for a jury to decide. But as long as they have an affidavit or an affirmation from an expert, someone they paid enough money the judge is always going to just punt it and say, issue of fact, let the jury decide. It's very rare. We just actually was granted one, and I was almost amazed the other day in Queens because the judge actually wrote a really good decision. But yeah, it's almost impossible now. It's almost a shame. New Jersey's a lot different than New York in that regard. So after depositions, the discovery or information gathering stage starts to wind down. At this point, you've obtained the medical records of the patient. You've obtained the medical records of how she is doing currently, where she's being treated, her current prognosis. We've now taken the depositions of all the parties. Their testimony was under oath. You'll learn as a physician who unfortunately may be involved in this process that once discovery has concluded, there is a time period in which your attorneys have the capability to make a motion. This is documents in writing to the court, specifically the judge, arguing that there was no departure from good and accepted medical care, that there was no causation, meaning that let's assume we did depart. It didn't cause the patient's harm or damages. It's our capability or one last hope to try to convince a judge through writing that this case does not deserve a jury. It does not deserve a trial. Now, when we make our motions, and it's a motion for summary judgment, you're basically asking the court to say the following, that there's no triable issue of fact, meaning there is no reason why a jury needs to hear this case, Your Honor, for the reasons set forth below. Now, in every motion for summary judgment, what we are saying to the court essentially is as follows. We have an expert who is going to testify that Dr. X did not depart from good and accepted medical care in the treatment that was rendered to this patient. What we argued in this case was that our client didn't see the patient, didn't speak to the patient, didn't treat the patient. Simply put, we argued there was no reason to keep our client in this case. We made a motion. Attached to our motion were affidavits of a board-certified dermatologist who opined that the care and treatment rendered by the practice, by the physician's assistant, was appropriate, and that the right recommendations were made to the patient, and that the patient unfortunately made the wrong decision. She didn't follow up with the plastic surgeon as recommended. In opposition to our motion, the plaintiff obtained a different dermatologist who opined and said to the court in papers, in writings, that my client departed, that she herself had an obligation to see the patient upon receipt of the laboratory results, that there was no mechanism by the office to follow up to see whether or not the patient actually followed the recommendations as made to see the plastic surgeon, and that my client was responsible for the physician's assistant because she employed him. The court has essentially one option. They review both of the records. They review both of the motions that were submitted to the court, and they make a determination. Should a jury decide this case? Was there a triable issue of fact raised by plaintiff's attorney? The fact that they had a doctor willing to testify as to the departures that my client committed automatically meant that our motion for summary judgment was going to be denied, and that this matter ultimately was going to be placed on the trial calendar and scheduled for a trial.
Okay. And with this specific case, it actually did not go to trial, correct? We decided to settle this case.
As we discussed earlier, we had a client who, as you know, we moved for summary judgment. Unfortunately, our motion for summary judgment was denied. The court felt that there was competing opinions by two separate experts, one for the plaintiff, one for the defendant. In those situations, the court felt that it would be best decided by a jury to hear this case. Now, we discussed the patient. She was young. She just finished college. She was going to become a teacher. She was enrolled in classes to become a teacher like her mother. The case was venued in Staten Island, New York, which is a small community, notwithstanding the fact that it's one of the boroughs in the city of New York. Things that go into the equation as to settle or not settle include the venue, i.e., where is the case located? The parties. How would the parties be as witnesses? The sympathy factor. Here we're dealing with a 21-year-old who unfortunately was terminal from cancer. The fact that the patient herself was Italian in a predominantly Italian community, that plays a role. The fact that the patient's mom was a local teacher in the community, that plays a role. Ultimately, after many discussions with our client, many discussions with her malpractice insurance company, a decision ultimately was made. Let's see if we could try to resolve this case pursuant to a settlement. Now, this case is different than most. The physician's assistant, who by all accounts was mostly responsible for what was described to be an alleged failure to diagnose melanoma or skin cancer, had different insurance company insuring him. He was a physician's assistant who had a separate insurance company. Now, sometimes this can create difficulty where you have two insurance companies insuring two specific or individual, whether it be a doctor or a PA or even a hospital if a hospital's named. In this case, thankfully, both insurance companies were cognizant of the pitfalls of going to trial. They were concerned. They were concerned what 6 lay people would decide when hearing the fact pattern, seeing the witnesses, and viewing the deposition testimony of the patient. And calls were made and conversations were held amongst defense counsel with different insurance companies involved. And ultimately, the overriding decision was, let's try to resolve this case pursuant to a confidential settlement. And ultimately, that is what occurred after many months of negotiations, with the court becoming involved, the judge becoming involved, and ultimately by even having family members appear for court conferences, including my client, who, again, while not treating the patient, was responsible for the actions or inactions of someone who worked for her. And ultimately, to benefit of everyone, the case did ultimately resolve.
Yeah, I was going to, that's probably the best resolution for all parties. Out of curiosity, was this settlement split 50-50 or what was the apportionment? Do you remember?
So the apportionment was 50-50. Yes, the case settled. Our clients were happy in the sense of not by the outcome. No one's ever happy by the outcome. But I think they took to heart the fact that the case was resolved. The family was able to go on with the last remaining days of her life. It was a 50-50 split. Our client agreed to that 50-50 split. The number, or what it settled for, was tolerable by everyone involved. And as you can imagine, ultimately, soon thereafter, the patient did die.
Yeah, it's a very unfortunate circumstance and case for that poor young woman.
It was. And Tammie, just if I may just interject, you know, there was it's a famous quote. I can't remember it specifically, but it goes as follows. Truth is not only stranger than fiction, it is more interesting. This is a quote by the famous publisher, William Randolph Hearst. And this case almost symbolizes that quote in that the physician's assistant, who was what we would describe to be the target of this suit, who plaintiff alleged failure to diagnose melanoma or skin cancer, approximately 1 year after the settlement was reached, the case was closed, was diagnosed with melanoma and died 1 year thereafter.
Oh, no, I did not know that.
Yeah.
That is terrible.
Yep.
Well, thanks, John, for joining us on the podcast today and for sharing that very devastating case involving a delay in diagnosis of malignant melanoma. Listeners, we hope you enjoyed this podcast. Remember to like, follow, and subscribe to The Verdict on Facebook, LinkedIn, Instagram, X, and YouTube. This podcast is for general purposes only and should not be construed as medical or legal advice. This podcast is not comprehensive and does not cover all possible factual circumstances. Because the facts applicable to your situation may vary, or the laws applicable in your jurisdiction may differ, please contact your attorney or other professional advisors for any questions related to legal, medical, dental, or professional obligations, the applicable state or federal laws, or other professional questions.